Greetings back again, part two. Sorry about the disruption. We're gonna leave off where we left off. All right, let's get back to where we were. All right, where are we at? All right, so we see here in the Dred Scott case, it says that here, the third section of Article 4 of the Constitution is referred to as the only all-sufficient grant to support the claim. It is that new states may be admitted by the Congress to this union, but no new states may be admitted by Congress to this union. But no new state should be formed or erected within the jurisdiction of any other state, nor any other state be formed by the junction of two or more states or parts of states without the consent of the legislature of the state concerned, as well as Congress. So we move a little further, it states down here, it is conceded in the decision of this court that Congress may secure the right of the United States in the public domain. When you say the public domain, you're talking about public land. When you're talking about public lands, you're talking about those lands that they must protect. All right, they don't own the land. All right, they don't own public lands. They only have right to to private lands by way of prescription. All right, it says that it may secure the rights of the United States in public domain, provide for the sale or lease of any part of it, and establish the validity of the title of the purchaser, and may organize territorial governments within the power of legislation. So they're talking about transfer and conveying of real estate. This is what they're talking about, all right? And proof of the transfer and conveyance of real estate, leasing, selling, all right? Not ownership, but the recognition of the plenary powers in Congress to dispose of the public domain or to organize a government over it does not imply a corresponding authority to determine the internal policy or to adjust the domestic relationship or the person who may lawfully inhabit the territory in which it is situated. A supreme power to make needful rules respecting the public domain and a similar power of framing laws to operate upon persons and things within the territorial limits which where it lies are distinguished by broad lines of demarcation of American history. This court has asserted us to define them. You can see Johnson versus McIntosh. You can see Martin versus Waddell. What else? You can see uh, it's another case that don't come to mind right quick, but it all deal with the public trust, which in the language of the cases dealing with the public trust, federal lands or what we call public lands. All right, they say according to the theory of the British Constitution, all vacant lands are vested in the crown, and the exclusive power to grant them as admitted to reside in the crown as a branch of the royal prerogative. All lands we hold were originally granted by the crown, and the establishment of the royal government has never been considered as impairing its rights to grant lands within the charter limits of such colonies. And the British Parliament did claim supremacy legislation coexisting with the absoluteness of the dominion of the sovereign over the crown land. So it said the British Parliament. It didn't say the English Parliament, y'all. It said the English Parliament because it said Great Britain brought into slavery and incorporated in the colonies, and at that time the colonies were subject to the British Parliament, i.e., the British Empire under the British government known as Great Britain in 1702. All right, this is how the colonies got their start. All right, this is how America got their start. This is the Dred Scott letting you know that you are migrants, you are slaves. You have always been slaves since the dark ages of the world. All right? Because we were ruling in the time of the Dark Ages where the Scottish kings were enslaved by Edward the First, not to the distinguishing as we were, but they were considered serfs. They were at war with the English king, Edward the First, when we know Edward the First were ruling not just over there in the territorial or the overseas possession under what they call the radical title of the kings, under what we call the Commonwealth, called Crown Land. This is considered Crown Land we're standing on. And it says, in the British Parliament did claim the supremacy of legislation coextensive with the absoluteness of the dominion of the sovereign over the crown lands. The American doctrine, to the contrary, is embodied in two brief resolutions of the people of Pennsylvania. And in 1774, that the inhabitants within the colonies, that the subjects born in England are entitled to with this realm. Did you hear that? That the inhabitants of the colonies are entitled to the same rights of liberties within the colonies that the subjects born in England are entitled to within this rim. Over here. Did you hear that? Over here. We know that these slave colliers were slaves. All right. You go back to slavery at the common law. Everybody pull that up. Slavery at the common law in the British Empire developed slowly over centuries and was characterized by inconsistent decisions and varying rationales for the treatment of slavery, the slave trade, and the rights of slaves and slave owners. Did you hear that? Unlike in its colonies within the home islands of Britain until 1807, except for statutes facilitating and taxing the international slave trade, there was virtually no legislative intervention in relations to slaves as property, and according to the common law, had something of free hand to develop untrammeled by the paralyzing hands of parliamentary draftsmen. Two attempts to pass the slave code via parliament in both failed, one in 1660 and the other in 1674. All right. Some scholars assert slavery was not recognized as lawful, often on the basis of pronouncements such as those attributed to Lord Mansfield, that the heir of England is too pure for any slave to breed. However, the true legal position has been both complex and contested in the 17th to 18th century. Some African slaves were openly held, bought, sold, and searched for when escaping within Britain. All right? So that brings me back to slavery in Britain. Slavery in Britain existed before the Roman occupation, and until the 11th century, when the Norman conquest of England resulted in the gradual merger of pre-conquest, i.e., conquistador, institutions of slavery into serfdom, and all slaves were no longer recognized separately in English law or custom. By the middle of the 12th century, the institution of slavery, as it had existed prior to the Norman conquest, had fully disappeared, but on the other forms of unfree servitude continued for some centuries. British merchants were a significant part behind the Atlantic slave trade between the 17th and 19th century, but no legislation was ever passed in England that legalized slavery. In the Somerset case of 1772, as mentioned in the Dred Scott case, Lord Mansfield ruled that as slavery was not recognized by English law, James Somerset, a slave who had been brought to England and then escaped, could not be forcibly sent to Jamaica for sale, and he was set free in Scotland. Collier coal mines slaves were still in use until 1799, where an act was passed with the established their freedom and made their slavery and bondage illegal. All right. So you see, Dred Scott case echoing the vibrations of the Somerset case as echoed by Lord Mansfield in regards to slaves being free in England. All right. Let's check out the Slave Act. The Colliers and Salters Scotland Act of 1775, an act of Parliament of Great Britain, which changed to working conditions of minors in Scotland. So if the Dred Scott case in regards to an African American from Missouri moving or running to a slave state and was not considered to be free and was brought back to his master from the state that he ran from to be free, and I think it was Illinois or Louisiana, one of those states. He was subject to the laws as regulated by Section 3 of Article 4 of the Constitution in regards to Fugitive Slave Act, and that was in regards to territory that was ceded to Great Britain, or what we said the United States. All right. And that was due to secessions to the Treaty of Paris of 1763, and whatever that was ceded to Paris, Great Britain in 1763 was treated to the United States in 1783. All right. So here we have legislation back in this ancient practice of servitude known as Colliers and Salters. All right. Colliers and Salters. And we know Colliers and Salters are those who work with coal. All right. Those who work with coal. Let's prove it. Collier. It's not Scottish origin. The name Collier finds its origin with the ancient Anglo-Saxon of England. It was given to one who worked as a person who made or sold charcoal. The surname Collier is derived from Old English word coal, which means coal. As such, it is thought to have originally been an occupational name for a burner of charcoal or a gatherer or a seller of coal. The name originated in Lancashire, i.e., the Lancaster branch. All right? The Lancaster branch. The word collier means charcoal, which originated in Lancaster. Let's look at the word color. Let's see. Before we go to color, let's look at the crest and coats of arms, everyone. Everybody see that? Yes, that's a colored person. All right? A collier or colored person means the same thing. Colored, collier means the same thing. All right? Let's see. Color. Color, history, family, crest, and coats of arms. The ancient and distinguished surname Color is German origin. The name derived from the Alemannic word collier, meaning charcoal burner, and was mostly likely originated born by a practitioner of this occupation. You see that? A practitioner of this occupation. All right, so color, charcoal, collier are one and the same. All right, they are one and the same. What brings me to this conclusion? All right, why am I saying this? Let me go here. And this is in closing. I know I had you for a minute. This is the case law from the United States Supreme Court, New Jersey Supreme Court. All right, the case is Gurbanat versus Deramere. Gurbanat versus Deramere. Because before I open up, I read you Jeremiah 45:4. For Jacob my servant's sake, and Israel my elect, I have even called thee by thy name. I have surnamed thee, though they have not known me. All right. It's very important to understand your surname because this is where your birthright derives from. This is where your inheritance derives from. This is the reason why you have these names. All right. This is why you have these names. All right. But having a name means nothing if you don't associate the name with the government. And at the time the name was given to you, there was a fusion of government. That's why you wasn't registered with biostatistics. You were registered with the church. All right. The church kept the record. All right. You must be a part of the church. All right. Because all the property belongs to the church. The crown, represented by the monarch who personifies the crown, protects the property of the church for his heirs, i.e., the inheritance. Why? Because he is the firstborn. Primogeniture. All right? Primogeniture. The question before the court on the United States Supreme Court, New Jersey Supreme Court of New Jersey, is about a case dealing with the best interest of the child. This case was on May 11, 1995. For the best interest of the child in regards to the surname, whether he was going to take the father's name or the mother's name. All right? Since surname is not a big issue, since y'all think surname is not a big issue, I'm going to show you that it is. All right? All right. Everybody pull that case. I'm going to give you a second to pull it up. Everybody must understand that you belong to somebody. You're somebody's property. Whether you're your mother, your father, God, the devil, the president, state, the judge, you belong to somebody. It's your job to prove you belong to. All right? This is in closing. All right? The question presented by this appeal concerns the right of the father in cases involving disputes over a child's surname to insist that the child bear his surname. The issue arises in the context of a child born to unmarried parents who were giving his mother's surname at birth. The father having refused to acknowledge the paternity, when the paternity was established by the test performed approximately 7 months later, the father acknowledged the paternity and commenced visitation. Shortly thereafter, the father instituted litigation seeking joint custody, increased visitation, and the change of the child's surname. The trial court awarded the father's joint custody and increased visitation, but the child's mother retained primary physical custody. Notice custody, all right? The trial court recognized the father's interest in maintaining his relationship with his child for their mutual benefit in order that the child assume the father's surname. The appellate division affirmed in its unreported opinion. All right? The appellate division affirmed in an unreported opinion. It's very important to understand what's being said here. Because we know that our surname denotes to patrilineal descent from your father, all right? And it denotes to the benefits that you get from your father or your mother. We know that comes into what we call partout sequitur via trim, all right? Father of the nation. Right now, You are abandoned children. All right. You're bastard children because you have no father. As a result of the registration system that they put you under by way of the birth certificate that's outside of the church. All right. Your surname is a form of baptism. It's a form of baptism. All right. Let's see what this case law says about that. All right. Because I don't want to be speaking abstractly. I want to give you the concrete. All right. Because we see Isaiah 45 that they gave you a surname in which he knows you by. All right. He knows you by the surname. But you don't know him by the surname because you don't know the relevance of the surname or the origin of the surname. All right. The recognition by the court below, a preference for paternal surname is supported by Western customs and law spanning more than 6 centuries. The practice of children assuming the father's surname is traceable to the English medieval property system in which the husband controlled all material property. You hear that? Material property. That preference continued in America, reflecting not only the long-standing English tradition, but also the societal distinctions in which status of men and women. Until the latter part of the century, the assumption that children would bear their father's surname was a matter of common understanding, and the preference for paternal surname was rarely challenged. But the historical justifications that once supported a tradition in the law for children to bear paternal surname has been overtaken by society's recognitions of full legal equality for women, an equality that is incompatible with the continued recognition of a presumption that the children must bear their father's surname. That presumption should no longer apply in this state. All right? They recognize the tradition, but they no longer apply the principles because they've taken out the primogeniture aspect of it, the firstborn. All right? Part one deals with the case at hand. We're going to go back to part, we're going to part two. Part two. The surname comes from the French word surname, sur, meaning above or beyond. Nom, from Latin nomen, meaning name. See how much these people know? Yvonne McChurna Pacquiao, Latino surname, formal and informal forces in the United States affecting the retention and use of the maternal surname. The use of surname is a relatively recent historical practice. In the early life of all races, surnames were unknown. While giving names have been used from the most distant time to identify and distinguish a particular individual from his fellow, that's the first name. From the beginning to the the Middle Ages, the term name referred to the giving or first name of the individual, as I just said. The Anglo-Saxon traditions of surnames dated back to the Norman conquest. Surnames are said to not have been used in England until the Norman conquest. Why? Because we were all family at that particular time. All right. Surname was given to distinguish from families from other families, based off what the surname denotes to. All right. You have names that denote the patrilineal descent, those to occupation, those to which is trade, those based off a skill. It can relate to anything. Profession, likes, a hobby, whatever. The Norman introduced a number of non-English given names such as Richard, Robert, and William, of which William became and remained the single most common record name in the 12th century. William is my great-grandfather's given name, but his surname is Jefferson. All right. My great-great-grandmother's name is Rideout, which actually originated in the Normans' time. All right, where the surnames originated. However, although each village or town might have only 10 Williams and a similar number of Roberts and Richards, distinctions often need to be made if two villages were talking about William. Misunderstandings would arise of each if each had a different William in mind. So qualifications were added, beginning with the influence exerted by the Normans following their conquest of England in the 11th century. The practice of adding second names became more common as relatively scarcity of Christian names led to a great number of people bearing the surname. All right? You can read all the other stuff on your own. At that time, owing to the paucity of Christian names, probably an estimate of 200 would cover them all. It became customary to add a name to that of baptism. Although the growth of population and the development of cities required a means of distinguishing between individuals with identical given names, the Normans also introduced a number of social practices. The imposition of a feudal land system and the use of primogeniture as a system of inheritance that likewise, pardon self, it said the imposition of a feudal land system and the use of primogeniture as a system of inheritance that likewise spurred the development of surnames. You hear that? Surnames came from a number of sources, including accidents, caprice, taste, and a multitude of other causes. Smith supra. Additionally, certain names expressive of kinship were chosen. The Normans brought with them a custom of naming sons after their fathers. As a convenience to the feudal system, the feudal lords could thus more easily identify sons of the soldiers most loyal to him. However, patronymic, a name derived from that of the father, was neither compelled nor universal. Inquiry into the naming practices of Western societies demonstrate that names ordinarily express kinship, but not necessarily paternity. Matronymics names derived from the maternal line have been employed in several Western cultures, including modern Spain and medieval England. In England, at least as late as the 14th century, both sons and daughters adopted their mother's surnames, often upon succeeding to their mother's estate or in hopes of doing so. And this is a result of marriage. Men also adopted their wives' surnames if the couple inherited property from the woman's family. The children of such couples presumably also took their mother's surname. Even among the non-property classes, children sometimes use the paternal surname. Historians of linguistics C.M. Matthews explains customs. An illegitimate boy might be called by his mother's name, but it was equally natural and useful to refer to the son of a highly respected widow in the same way, or even when the father was alive, but away for years on some distant expedition or marriage to a dominant wife, the lad might be spoken of as belonging to Moll or Allison or Marjorie. This is talking about a crusade, all right, crusader. The paternal surname, even if initially bestowed, did not necessarily survive the father's absence. Many of the English matronymics are still in use. As many as 1/10 of contemporary English surnames of relationships, as contrast to those derived from the name of places or occupations, were originally matronymic. Eventually, the medieval property structure, which invested all the marital property in the husband, and the firm and exclusive establishment of primogeniture in the 14th century resulted in the widespread use of hereditary paternal surname. Sometime after the early 14th century, surnames began to serve as hereditary family names, partly because the inheritance of property was often contingent upon the heir's retention of the surname associated with the property. Did everybody hear that? The custom of patrilineal succession evolved from the medieval property system in which the husband controlled all marital property. In addition, a married woman in medieval times could not contract maintain a suit in her own name. Hold that thought 1 second. All right. What was that? It said, in addition, a married woman in medieval times could not contract or maintain suits in her own name. The male was the legal representative of the family, and is as such enjoyed the unilateral right to the name to name his family. The custom of patrilineal succession seems to have been a response to England's medieval social and legal system, which came to vest all rights of ownership and management of marital property in the husband. As one of the commenters noted, the mechanics of recording entitlement to land prompted the retention of the paternal surname. The land could be claimed and awarded only at the manorial court, being held by a copy of the court roll, which meant that the life tenant name was inscribed there on permanent record. This system provided a direct incentive to men to keep the same surname that had been put down on the roll for their father or grandfather, or even younger sons, having in mind the uncertainty of life, might think it just as well to use the name too, even if it was well belly or chicken head. All right. So as we can see, on the reversion manner of state of life estates which are fee and simple, it can be done if it's an entail estate. All right. The customary use of hereditary parental surnames were further institutionalized during the reign of Henry VIII of England in the early 16th century. The kings established parish registry systems governing the recording of births, marriages, and deaths. Each parish had to keep records of the births, marriages, and deaths of the parish inhabitants. This is your county records, y'all. The effect was to encourage families to identify themselves under the father's name for recording purposes. This recording of such events in every family led to the use of one's name to designate the members of one family, which the records served to perpetuate, transmitting in it from father to son until practice became a general for all descendants to bear and become known by the name of a common ancestor. All right? The trend seemed to have been hastened by the promulgation of a regulation during the reign of Henry VIII that required a record to be kept in every parish of the birth, marriage, and death of the parish inhabitants, with legitimate births generally being recorded in the name of the father. The budding tradition is further continued when Henry VIII required marital births to be recorded under the name of the father. Certain benefits of that practice accrued to the crown. Did everybody hear that? Easier identification of citizens will permit the government to call upon the citizen for purposes of taxation and other ways of serving the government. The government bestows the patronymic name upon each child whose parents were married, thus further legitimizing the child through the naming process. The father was also legitimized for bringing forth a new heir subject to the king. The matronymic, inviolably, the institutionalized tradition of assuming the hereditary patronymic surname and secondary legal status of women in England diminished the importance of maternal surname as one commentator observed. All right, point so. The matronymic name, on the other hand, was not even considered in this naming or recording process, nor was it viewed with the same legal or legitimacy as that of paternal name. Although it was the mother who gave birth, who gave to the child part of her identity, she could not give the child her name. The English crown had no interest in the mother's surname. It was not deemed legitimate or worth perpetuating. This is case law. Y'all hear? This is case law. However, a distinction in English common law arose in respect to a child born of unmarried parents. At common law, an illegitimate child was filius nullius, the son of no one, or filius populi, the son of the people. The child has no mother or father recognized by law, and therefore has no legal rights. Because the child could not inherit property, the impetus to bear the paternal surname was diminished. Customs did not dictate the name by which an illegitimate child would be known. The child bore the name gained by reputation in the community. It has been reported that under English law, a legitimate child acquired no name at birth, could only be acquired a surname by reputation. He acquired the name of neither mother nor father and only assumed a surname later in life based on some factor other than lineage. All right, the birth certificate. At early common law, an illegitimate child was known as nullius filius, or son of nobody, and consequently did not acquire a hereditary surname from either his father or mother. Their surname was that which he later gained by reputation. This is why there's no nationality on your birth certificate. Traditionally, use of the paternal name was brought to this country by the colonists. Did you hear that? The traditional use of the paternal surname was brought to the country by the colonists. The historical reviews clearly demonstrate that the continuation of English customs of patronymic surname in the colonies was intrinsically linked to greater social forces, particularly to inferior legal status of the woman. All right? So they changed it from paternal to maternal to the woman by way of them colonizing here and starting a new inheritable process that's not based off another succession. That's the whole problem of why we got in this predicament in the first place. All right? In closing, in contrast, the rule of the father of the household over his family had been described as a diminutive version of the reign of the king over his people. The head of the household remaining a kind of miniature king, a governor or protector to whom respect and subjection was due. It has been suggested that the bestowal of paternal surnames upon a child not only has its basis in custom, but as the absolute role a father has as head of his family. For himself. The father position in the family was expressed in the Spectator, an influential periodical in America and England. Noting is more nothing is more gratifying to the mind of a man than the power and dominion. And as I am the father of a family, I am perpetually taking up and giving out orders and prescribing duties and hearing parties and administering justice and distributing rewards and punishment. In short, sir, I look upon my family as the patriarchal sovereignty, in which I am myself both king and priest. And in closing, the retention of the English law of primogeniture and the related practice of entail, which allowed the testator to keep land intact by passing it through the stem line of the family, ensured that the land belonged to the male line and continued the custom of children receiving the male surname. All right? And when the crown land is entail. As you can see here, crown land, also known as royal domain, the territorial area belongs to the monarch who personifies the crown. Tell me who out there and on any platform have personified the crown in lieu of incorporating the laws of those people who personified the crown from olden days. No one has done that except me. All right. In lieu of an entail estate, which is inheritable, going back to Edward I when the New Jersey abolished it. All right. New Jersey abolished the entail estate that was left for you, the heirs of the Plantagenet crown, who was left by my father, Godfrey the Fifth Count of Anjou. So it's only right in lieu of my royal prerogatives and my royal power under my jury regalia is if we turn that illustrious estate back to you. So I hope today's lesson was not confusing to you. I hope that you really take what's being said to you seriously and use Dred Scott case and the other case I gave you as the paddles for you to make your way onto dry land from the Admiralty waters that you've been traveling for so long. All right. So I love you all. Uh, please leave your comments as well as if you are able to donate your gifts. You can send them to the $ Clifford Jefferson L or the Third Timothy English Church of England, and as well as leave your comments as well as register and show yourself according as coming home by registering with the temple according to said surname. And with that, we here at the Third Timothy English Church of England say peace.